of today's list.
24.
24, Lordship. Lordship, here, Lordship had directed us to file an affidavit, Lordship. Here, if it is complete, at least more time to file the affidavit. I will inform the petitioner, my lord. And
Mr. A. Solia, Learned Counsel, appearing for the Learned Standing Counsel, Finance Department, prays that he be given a week's time to bring on record the stand of the said authorities by way of filing an affidavit. Full stop. The prayer is not objected to by the Learned Counsel for the petitioners. Registry. Prayer accepted. Registry to list this matter again after 2 weeks or date to fix by.
My lord, with the consent of item number 15 to 20, that series, my lord. I was not aware, my lord, that WPT BC. I have just been informed that, my lord, it's a WPT.
What is there now?
I don't know, my lord. I haven't seen the file even, my lord.
You wait, let them come. Wait. Because I've gone through it, 2013 matters with regard to that inclusion in the Rabahazong area. You had taken a policy that first it was Rabha 50%, then you converted it to that it will be scheduled tribes. 50%, then do it. I don't find any material. Let them come. You be here. 2013 matter, we'll see what can be done. 9? No adjournment. No adjournment. Huh? Who?
Honorable Joseph Gardick.
It's a partnered matter.
Partnered matter by my lord Justice Katak Ete.
Okay, so file tomorrow. Is there an order there?
Yes, your lord.
Okay. It is stated at the bar that on item number 9 to, why is it listed before me then? 9 to 12, was it not like 9 to 12 is already being heard by a coordinated bench of this court, and the matter has been kept partnered by the said bench. Full stop. Accordingly, registry to verify the matter and list the same before the appropriate bench.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 4, my lord. In this case, my lord, I want to file rejoinder affidavit, my lord. Sometime maybe granted instruction receipt, my lord.
What is there? Secretary, you were the designer earlier, right?
No, I am for respondent. I am for
You are for respondent. Okay, petitioner is there. Let them make the submissions. Let them make their submissions. You are appearing for whom?
All the respondent, my lord.
You have filed an affidavit. There is an affidavit on record.
No. Here, I am filed affidavit, my lord.
Ah.
They file reply, my lord. I want to file.
Reply to reply.
Rejoinder, my lord. Affidavit.
Let it reach. Let it reach.
May I please, your lordship? I beg to mention item number 23. Maybe password for the day, my lord. Maybe adjourn for the with the consent of the other side.
Why?
We have to get some instruction about
That was the prayer made on the last occasion also. What is there in this matter anymore? Where is Mr. Ghosh?
He is coming.
Let him come. We should also have some work. If you don't want to do it, you should have told me yesterday. I would not have gone through it. Have some. Let it come.
Supplementary course list, delivery of order item 25.
Madam, that day you were making some submission with regard to that maths thing. What was that?
My lord, as per the OM, my lord, it specifically stated that postgraduate teacher in the school where he is a teacher, my lord.
Can you just refer to that?
Yes, my lord.
Page
It's page number 39A, annexure 10.
39 of the repetition.
My lord, of the repetition, my lord.
39.
39A, my lord. Annexure 10. It's stated at leadership skills, my lord may kindly see the third line, the school. It says that case of postgraduate teacher in the school where he is a teacher, my lord. Not on the subject, he is a teacher, my lord. My submission is that. Secondly, my lord, my lord, as per the order of this honorable court, my lord, division bench, they have been declared as a graduate teacher, demonstrator, my lord. So from the very beginning of the filing of the writ petition, the plea was open to them with regard to challenge either that writ appeal order to, with regard to not consider them as a demonstrator, as a postgraduate teacher, because all the demonstrators, my lord, are teaching this. So their
So
plea
you mean
was
to say
open.
they'll be postgraduate teacher?
My lord, they have, no, I am a postgraduate teacher, he is a graduate teacher. So according to, my lord, the notification, his marks will be considered with regard to HSLC. SSLC. Their plea was that since they teach the subjects of chemistry, that is not a domain of HSLC, so they may be taken into consideration, but that goes against the OM. They have not challenged this OM, my lord. Neither they have challenged the.
But will their not case also be covered by this definition postgraduate teacher?
My lord, because this is results of SSLC examination in case of graduate teacher and SS final examination in case of postgraduate.
What is a demonstrator?
Demonstrator, my lord, he is considered as a graduate teacher, my lord.
By the division bench?
My lord, my lord. So, my lord, as per that, as per the OM, the results of SSLC will be taken into consideration.
Okay.
My lord, their plea was, it was open since the filing of the writ petition, either to challenge the division bench order, either to challenge the OM. None of them has been done, my lord.
Okay.
So this is my case, and my case covered with regard to, I have submitted the marks, my lord, that the participate.
Okay, disposal.
Delhi course
Okay,
list,
fine.
admission item 1.
Lordship, in this matter, the respondent, they have filed their affidavit. We need some instruction from the petitioner, your lordship.
What instruction will your petitioner give you?
Your lordship.
Where is Ms. Ghosh?
Lordship, she is out of station, her leave note is reflected in the court list.
Mr.
She instructed me
Gogoi,
for an accommodation for a week. Your lordship.
this is a case of postpartum eclampsia.
Lordship.
I only want to see what treatment was given to, because that is not reflected in your affidavit. You say you tried to rescue her,
Yes.
she went into coma. This is a condition that can happen to anyone. But there is a prescribed procedure for treatment.
My lord.
You will have to give them what? Fluids. You will have to give them magnesium. There is you will have that treatment records with you,
Yes,
both of the referral hospital and the FMCH. Huh?
Lordship,
Can you get those?
I can, yes.
Let's see if everything is okay, because this is not something which you can always focus. It can happen to anyone. That's my research, what I found out.
Lordship.
So if that treatment procedure was followed, then only that 20,000 she'll be entitled to. But if you have not followed that, then we will have to consider giving her some compensation. Right?
Well,
Mr. D. Gogoi, Learned Counsel for the petitioner, is required to procure the treatment records pertaining to this petition is by the daughter. Treatment records of the mother of the petitioner hearing, both at what is that first institution? Both at the subdivisional civil hospital Patsala, as well as at the, what do you call it? FAA MCH, right? That'll do.
Fakhruddin Ali Ahmed Medical
Huh?
College and Hospital. Fakhruddin Ali Ahmed Medical
And at
College. and
Fakhruddin Ali Ahmed Medical College and Hospital, Beta.
FAL.
Also, list this matter again next week.
No, if I can.
List this matter again. On 11/6/2024. Get that? if she has been provided with the appropriate treatment, why will we?
That may be reflected, Madam, so that I can
Huh?
communicate. That record is required. That
Ah,
may be-
I've procured the records.
Madam,
Procure the records, full stop. List the matter again on 11/6/2024 for production of the said records as called for.
Item 2.
Next, please, your lordship.
Has the materials been returned to you?
Materials has been provisionally released, lord,
Okay,
long time. Lordship, in this case, we are challenging the procedure of seizure that they have followed because it is totally against the provisions of law.
Mm.
Section 7(1)(c) of the Customs Act 1962, that is what they have applied in our case will not be applicable in our case. Section 110 of Customs Act, that has not been followed. Section 124 of the Customs Act, that has not been followed. So no procedures had been followed and they have misused their powers and done this seizure and harassed the person's lordship.
is there an interim order operating here?
Lordship,
There is no interim order operating, only the release order is there.
release of the
The
goods.
proceedings have not been stayed.
No, lordship.
What happened? Have they proceeded? No.
They have proceeded and
Ah.
we have cooperated also. We have given a statement also, which they said in their affidavit that we have not we have not present ourselves before the authorities and we have,
One statement.
but we have given our statements, lordship. I myself was present there with the client.
Now we can't say anything. Now we can't say anything. She has taken it on her.
And even Shillong office also we visited, lordship.
Hmm.
Wherever they have given, from wherever the summons had come, we had represented their lordship.
Okay.
Lordship, may I come to the first, lordship? I'll take lordship to the facts of the case, lordship.
Hmm.
The first thing is the detention received, lordship.
Mr. Cal, we'll proceed.
Yes, lordship, but record lordship, I can produce at 2 o'clock.
Then what is the point in hearing?
Because earlier it was with me, because the lordship, this case is check study. Earlier. hearing was
Because in
completed
your
at 12.
affidavit, the contentions are that are there. Basically, with regard to the records, their appearance, their non-appearance.
It's at 2 o'clock because it is coming. I've already requested that record. There was on last occasion, we submitted our written argument also.
Where? Here? Who heard it?
In this record, Lord, earlier it was kept CAB. Was CAB
Lordship, for 2 years, it was
2 or 3
CAV
or 3
with
years,
Justice M.R. Pathak, lordship.
It was,
So that is why this lot of judgments are there.
Yes,
Yes,
your lordship. There's a compilation also.
Compilation also. I've gone through it. It was beneficial for me. You get your records. We'll have it at 2 tomorrow.
tomorrow.
Tomorrow we
Day
are,
after.
lordship, Friday too.
Friday too.
Friday,
Friday.
lordship, I'm going outside. Then
Thursday.
Then 12
Thursday.
Wednesday, Thursday, I'm not there, lordship. Tomorrow.
on
I'm-
Thursday. The very all metal. Lordship. On Thursday, lordship.
Thursday, not possible, lordship. I'll not be
Or
there.
then
Wednesday.
Monday.
Monday, yes, yes.
Then lordship Tuesday, because I'm depending on Monday, lordship. On Tuesday.
Lordship, if,
2 o'clock today.
Yes,
lordship,
I
lordship,
place the 2 o'clock.
lordship, only
2 o'clock.
one thing. If this can be admitted and kept in the hearing.
No. No admissions. We are finishing it off. We have read it.
At 2 o'clock, lordship, I'm putting here.
Monday.
Monday.
Monday, lordship, and it.
Tuesday, sorry. No further things are required. This is the material. What is your grounds? Tell me.
Lordship, my grounds is that the seizure has been done first. Section 110 says that first the reasonable belief has to be created by the officer who is going to see.
You were coming on a plane. This was coming from
This
Calcutta
was,
on a.
no, this was not coming on the way. And the main thing is that Custom Act applies when it is import and export in
This is
India.
within the country
This
itself.
is the domestic flight going from Guwahati to Kolkata,
Kolkata.
all jewelry going for repair.
That
So
is
this-
your,
There is no question of
then you
attracting money
produce
there.
those documents.
Yes,
And what was their response to that?
when we have, they are telling those.
What
of
is the final, what decision have they arrived at?
No, they have
After,
not arrived at any decision
Why?
till now.
Proceeding is going on, lordship, there, in the mean.
this is a 17 matter. Because they have given you, according to their statement, they have given you the documents, invoices and all.
We have made specific environments in our affidavit that the petitioner is not cooperating with the investigation.
That's why I want the records. Because
sir.
she says she was there.
Yes, Lord, shall produce the entire original record, sir.
Lordship will be surprised to see the record.
You come back at 2
Yes,
today itself,
I'll-
2 o'clock.
Much of it. Tuesday.
No, today,
Today.
2 o'clock. You are getting the records at 2. Come back at 2.
Item 3.
Hmm.
The petitioner herein had constructed a building with due permission from the Silchar Development Board, Lordship. Thereafter, Lordship, she made a in 2015, Lordship.
What is the
annexed.
appellate forum from the orders of this chairman? Is there any appellate forum available?
Lordship cannot hear, Lordship.
Is there any appellate forum available against this order at the Annexure 5 order, page 24?
Lordship, appellate forum, I have no
No.
idea.
Okay.
My
Your case
prayer
is.
is simple here, Lordship.
Hmm.
That I had made, Lordship, a presentation in 2015 itself, prior to the complaint made by the respondent number 2. That,
Now, both of you seem to have violated the norms.
no, Lordship, without causing any inquiry, though it was done behind my back, if it has been done. Any inquiry that I have constructed my house in violation of the rules, Lordship. Nothing has been done. So, Lordship, my simple prayer is that to dispose of my presentation in 2015, which I made prior to that, and to pass the Lordship, the impugn order, Lordship. So this will suffice, Lordship, because a fresh inquiry may be carried out by the authorities, Lordship.
You were given a notice.
Lordship.
You were given a notice. You were given a notice.
Yes, Lordship.
You replied.
Replied, but Lordship, they are saying that in my reply, I said I have not violated.
Hmm.
But
Who is appearing for the Silchar Development Authority?
May I please, my lord?
Oh, you are appearing?
On behalf of Mr. SP Chaudhary, my lord, I may.
Yes. What is your stand? What are the materials that you have considered
Yes.
for passing this order?
My lord, right now we are having the.
Why have you not filed an affidavit here?
Sorry, my lord.
You have not filed an affidavit? Then
Received this order sheet from the department. When the proceeding was carried on, they have been served the notice. At that point, they are not present in the entire proceeding. On behalf of the complaint which was received. by
I'm
the-
not what is there.
Yes.
Those proceedings were instituted sometime in 2019.
Yes, Lord.
Did you have notice of these proceedings? Present proceedings?
Yes, Lordship.
You have the notice of these proceedings?
Yes, yes, Lord.
What is your stand?
My lord,
Where is your affidavit? Why from 2019 an affidavit was not filed?
Lordship, we need some time for that.
Why? Why? 2019 onwards you are sleeping. We'll interfere. Non-Travis. Why? Give me a reason. When did you appear appearance in these proceedings?
We have paid earlier also.
Then
My lord, we have sent our. Well, some kind of information.
2019 to 2024, you have no information. What information will you get further?
Lordship, right now, order sheet on the basis of which the entire proceeding was conducted. Whether the proceeding which was held was lawful or not, because the notice was issued to them and accordingly the parties appeared.
I only want the materials on which you have reached this conclusion. It cannot be only on the basis of a notice and
As per the order.
there has
sheet-
to be a field
Yes,
verification.
Lord.
Where is that field verification? Page 23. Come to that page 23. That is the field verification report by some authority. And herein you will see clear violation on both the parties. What have you done for the other complainant?
Lordship.
Who is appearing for the complainant? You are appearing. What is your stand? You have also not filed an affidavit. We'll direct both the Silchar Development Authority to carry out a field verification immediately with regard to both of you, and whatever the offending is which cannot be compounded, to demolish. Both of you, right? We'll do that.
Fresh inquiry maybe lordship.
No, no, field inquiry. And if we they find that either of you have violated, to demolish. You get hold of the records.
Because lordship, permission, we have taken the due permission.
Due
That is it.
permission, you have not kept the setback. That is the allegation against you.
But lordship, from the lordship petition, it can be seen that I had filed a complaint in way back in 2015. They have not acted on it. Till
We'll have it on Wednesday. Get your records. Oh, sorry, Thursday. Get your
Thursday,
records.
lordship, may I pray Thursday, it will be difficult.
Friday,
Lordship,
Friday.
can it be after 13, on 14th or any date, lordship?
Why?
Lordship, I have got some difficulty, lordship. On 14th or any date, lordship.
I heard Mr. A. Tavildar, Learned Counsel for the petitioner. Also heard Mr.
Vishwakarma,
You are
K. Vishwakarma on behalf
A.
of.
Vishwakarma appearing on for the respond number 1 and Mr. L.R. Mozumdar appearing for the respond number 2. Also, Mr. K. Vishwakarma, Learned Counsel appearing for the Silchar Development Authority is directed to produce before this court the records leading records of the matter, the records of the proceeding leading to the issuance of the order dated 9/5/2019 impugned in the present proceedings. Also, the said records be produced before this court on the next date of listing, that is on next date of listing. Full stop. Registry to list this matter again on 18/6/2024. Get those records.
Yes, sir.
And why don't you file an affidavit here? 2-page affidavit will do.
Obliged, lordship.
Item 4.
Yes,
Lordship. This is non-release of granting in amount, lordship, partially released, partially not released, lordship.
partially not released, they have a stand for that. They say you're not entitled.
Lordship. Only for 22 days, but they have.
They say that the designer and the secretary cannot be the same man.
Lordship,
So
that is the condition.
whether it is 22 days or 1 month or 1 year or 2 years, how can this court determine?
Lordship, the situation was like that only, lordship. When the project was supposed to be completed, only 22 days was remaining, then he became the secretary, lordship. Otherwise, he was not the member of the society, lordship. And accordingly, lordship, annexure 14, lordship, in page number 14, lordship, annexure 2 of my writ petition, design fee for 1 month was directed to be deducted, lordship. Page number 14 of my writ petition, lordship. In this connection, it is recommended to deduct the designer fee for 1 month. And after that, they are going to deduct the entire fee for 6 months designer fee, lordship.
Come to page 15.
Yes, lordship.
What is this DCHC? That is the Development Commissioner Handloom and Handicrafts sanctioned amount.
This is 7,03,600.
So the balance 3 lakhs, who is to pay?
Yes, the balance remains 2,03,600 rupees.
No. You see, sanction amount 10 lakhs,
Yes, lordship.
DC's share of the admitted expenditure 7 odd.
They have taken that we have in conducting the project, we have expended amount of rupees 7,03,600.
Because you were treated as a member of you were treated as that part of the society. So no extra payment to you.
Yes, that's they have taken, that's.
Okay, now see, 5 lakhs they have given you another 2 lakhs. So that is 7,03,660. Where is this breakup of 7,03,660?
That is not there, lordship.
And where can you show the breakup of 10 lakhs?
Out of this 10 lakhs rupees, 5 lakhs, they have released.
First installment.
Yes, lordship.
Hmm.
This breakup is, lordship, then we have to call for the records of this project, lordship. Then. Because they have to come to this is, they have also stated in their affidavit in opposition, Lordship, that we have a prototype cost, we have shown it
Okay,
is higher.
why did you deduct that designer fee when you have already said that that will not be applicable for 1 month? Why did you deduct it for 6 months?
My lord, I,
Para 8,
Yes.
page
yes.
27 of your affidavit.
My lord, I have filed my affidavit, lordship may come to my affidavit.
Para 8. What is the justification for this?
Their justification is that this designer fee is not fractionable, Lordship.
My lord,
That is the only justification.
lordship,
250,000 is the disputed amount.
250,000 is the disputed one.
my lord, lordship may come to my affidavit, my lord. Affidavit of origin, my lord.
Hmm.
Para.
Para?
Para 10.
Para 10. Hmm.
My lord, subpara, my lord, moreover, the contention of the petitioner is self. The petitioner has accepted that amount of of the granting aid and submitted three receipts dated 12 to my lord. Annexure 2, my lord, 39, my lord.
Okay. Yes,
Yes, Lordship.
page 39.
That explanation I have. Lordship, if you come to my affidavit in reply, Lordship, page number 61, Lordship.
61.
Yes, Lordship.
Hmm.
Column 1, Lordship, temporary advance, last part, Lordship. Taken from the president of the society as temporary advance for conducting the workshops, 5,26,850 rupees we have taken as loan, Lordship. So after completion of the project, Lordship, we are in urgent need of money. So ultimately they have stated that we are eligible for that much amount only. So through this pre-receipt bill, we agreed initially to accept that amount.
sounds okay, isn't it? नहीं ना पाएगा माजू है माजे मुझे मिसो yes madam, which paragraph?
Lordship will find supervision and involvement of SEBI in the sale process and refund. So we have noted, given these clauses at 12, 13, 14, 15, 16, and 17. Up to 19, Lordship. This is what we want to come, want them to come. Details of the money.
And you wanted it to be done by an independent valuer. They have to, but they have not done that.
Lordship, we have submitted the valuation
Yes,
report.
the balance sheet would not do the details
Balance
of
sheet,
this.
the valuation report we have submitted, Lordship, in the
No, but the
rejoinder.
details,
Valuation
know-
report is valued by the government registered valuer, Lordship.
we want to know the type of securities, the number of investors, all this must be there. Only then we know how the refund. You know.
Because that just throwing some papers to SEBI will not do. You will have to give
Yes,
them
so
the full,
giving the balance
full
sheet,
particulars.
Lordship, these are the things we have,
They have given a detail. Have you filed a reply to this SEBI's affidavit?
Lordship, yes, rejoinder yesterday only. we have
You have
filed.
filed to this
Yes,
affidavit.
Yesterday only.
what have they filed? They have filed the balance sheet and the valuation report. That not
Yes.
give us anything.
Lordship,
So what is madam saying? That is nothing.
Balance sheet would not show who are the investors.
Lordship, actually, since 2012, there is no any activity of the companies. Since then, it is closed.
You are not required
No,
to,
what
you're
is
not
that?
required to file your
Yes, 2015,
statutory returns.
16, Lordship, 2000.
No, no, if your company is not functioning also, you are not required to, it has not been liquidated. Company is still, it's a
No,
good,
not running, Lordship.
It is not.
It is not right. It is, it has been-
then
Lordship.
you are required to file. Am I wrong in saying that they are required to file their returns? Yeah. Until and unless they are liquidated.
Absolutely.
Up to 15, 16, we have filed, we have submitted, Lordship. 2011, 12 to 2015.
We are
16, have
nowadays a
submitted.
green coat, madam. Madam, we are a green coat. Birds have also started coming in.
Seems.
Lordship, others we are trying because all
Okay.
of the,
We'll have that affidavit on record. Hmm. And madam, on the next date, we'll have it on a date convenient to you. Kindly, if possible, a 2-page note, if you can give me, as to how you want the petitioner to,
Absolutely.
then we can proceed in the matter, because this is basically concerning the money of the public, and we want to
Absolutely.
ensure that the money reaches them.
That is the reason we now want to know the issue. How,
You just give it point-wise that these are the things they mandatorily must give us.
right, but we'll do that.
But Mr. K.H. Khandakar, Learned Counsel for the petitioner, also heard Ms. M. Hajorika, Learned Senior Counsel, assisted by, Madam, you are assisted by
D. Khan.
D.
Khan.
Khan, Learned Counsel, appearing for the respondents number 4 and 5. 4 and 5. Also heard Mr. S. Roy, Learned Counsel, Learned Government Advocate, appearing for the respondents number 1, 2, 3, 6, 7, 8, 9, 10, and 11. Also, it is submitted by the Learned Counsel for the petitioner that an affidavit, a rejoinder affidavit has been filed yesterday in the matter against the affidavit filed on behalf of the respondent number 4 and 5. Also, however, the same is not available on record. Registry to trace and tag the records of the said affidavit rejoinder along with the records of this case. Also, on the next date of Ms. Hajorika, Ms. Hajorika, Learned Senior Counsel, has submitted that on perusal of the affidavit stated to be affidavit filed by rejoinder filed by the petitioner hearing, it is seen that the detailed balance sheet as required with all the requisite particulars have not been furnished by the petitioner, and for the reason of which the SEBI authorities are not in a position to finally adjudicate the matter and to determine as to the assets and liabilities of the company involved. Also, Ms. Hajorika on the next day, Mr. Senior Counsel, Mr. D. Khan, Learned Counsel, assisting Ms. Hajorika on the next date of listing shall place on record a written note with regard to the specific requirements of the SEBI in the matter which have to be met as per the statutory provisions by the petitioner in the matter. Full stop. List this matter again. When, ma'am?
Whenever it's convenient to Lordship. Little
Next
time.
week. Anyway, I'm here next week whenever it's convenient to you.
Lordship, next week will not be possible. We have to collect the others balance sheet.
That we will see. Let madam come up. On Friday or Monday, whenever it's convenient to you. So just for that purpose,
Next week, Friday, Lordship, in that even 14.
14. The list again on 14/6/2024. Madam, you just give that note so that if you can give it a day ahead, so I can also come and then we will formulate.
I'll do.
Daily course list, orders item 6 and 7.
Yes.
May I please your lordship? Lordship, lordship may take up item 7 first, the WPC 6786.
So you are basically aggrieved by the order of
Order,
this.
lordship, order.
Now you come, what are you challenging here?
Lordship.
You are challenging the
Lordship,
order.
Lordship, the grounds for rejecting my case, page 174, lordship, may come to the grounds, lordship, firstly. The ground starts at page 174. Lordship, got it?
Okay.
Lordship, the first ground, they have stated there are some inconsistencies as regard the petitioner's date of appointment, date of joining and designation. This is the first ground, lordship. Then page 175 is the second ground. The petitioner was appointed before acquiring the requisite qualifications for the post of Hindi teacher. The third ground is there was no vacant post of Hindi teacher in the Paschim Bonbhag Anchalik High School during the period 1999-2001 to 26/6/2009.
So what are the materials in your support against this? Three grounds.
Lordship, firstly, all these issues were already dealt by this honorable court.
Where? Show me that.
Lordship, the order starts at page 122.
120.
122, Lordship. 122.
Mm.
And the relevant part first, I'll take to Lordship 146. First, the issue regarding the qualification, page 146. Second line. May I read, Lordship?
Mm.
From the materials, Lordship got it, second line.
From the materials on record.
From the materials on record, what transpires from the admitted facts is that the petitioner was issued a provisional pass certificate on 21/10/2001, wherein it has been mentioned that the petitioner under roll number 2942 had passed the exam of Madhyama Visharad from Hindi Sahitya Sammelan of Center Dhamdhama in the year 2001. There is no challenge to the said provisional certificate. It further appears that subsequent thereto on 30/4/2002, the mark sheet of the petitioner was issued bearing the same roll number being 2942, and further to that on 9/8/2002, the final pass certificate was issued. All these certificates are subject matter of dispute. It may not be out of place to mention that it is a practice followed of issuing a provisional pass certificate followed by the mark sheet as well as the final certificate. The respondents have not been able to show any other practice followed or have denied the said practice. The late issuance of the final pass certificate as well as mark sheet cannot be a reason to nullify the provisional pass certificate dated 21/10/2001. Therefore, as on 21/10/2001, the petitioner had duly passed the Madhyama Visharad from Hindi Sahitya Sammelan of Center Dhamdhama in the year 2001.
Mm.
Then Lordship may come to page 150. 150, paragraph 42.
Fourth line, Lordship.
Another reason.
Another reason why the claim of the petitioner was rejected is that the petitioner was appointed prior to acquiring a degree in Madhyama Visharad and actual production of pass certificate. This court is of the opinion that the commissioner and secretary, while passing the impugn order, have completely failed to take into account that there was a provisional pass certificate issued on 21
Okay, got it.
2001.
Got it. The next ground.
Then, Lordship, page 151 regarding the multiplicity of dates of appointment.
Hmm.
Page 151, paragraph 43. Paragraph 43, the other ground taken for rejecting the contention of the petitioner by the commissioner and secretary was that there were multiple dates of appointment recorded in the different official records. But surprisingly, the commissioner and secretary did not take into consideration that the inspector of schools has given a provisional approval to the petitioner's appointment on 9/9/2004, which clearly shows that the petitioner's appointment was provisionally approved in the official records as on 9/9/2004. It would have been understandable if the respondent number 5's appointment was prior to 2/8/2002, and the question of various dates of appointment would have been germane. But admittedly, till 2009, the respondent number 5 was nowhere in the scene. Further to that, the commission.
Respondent number 5 here is Abdul Qadir.
Lordship.
Hmm.
Further to that, the commissioner and secretary failed to take into consideration that on 19/7/2006, the inspector of schools MDC Nalbari had forwarded the names of the various teachers for orientation course, and the petitioner's name duly appeared at serial number 33, wherein it has been shown that the petitioner was a Hindi teacher in respect of the schooling question. The completion certificate was issued on 12/8/2006. There were clear materials on the records that the petitioner was duly appointed in the school as a Hindi teacher prior to the respondent number 5. Lordship, then page 140 regarding the issue of sending to the tribunal also, that was also decided.
No, where is that issue with regard to already a teacher figuring in the school?
Lordship, here I have stated in page 37, Lordship.
No, in the order.
Lordship.
In this order,
Lordship.
was that point also examined?
Lordship, I have.
Because the order by which your case was rejected,
Lordship.
it also says inconsistencies, appointment. There was no vacant post. 3. During the period 19/9/2001 to 26/9/2009. Where is this?
Lordship, at that time, Lordship, the petitioner was sent to Hindi teacher training. He was working in the school. There is no doubt about it.
What is this? There is no vacant post of Hindi teacher in Panchim during the period 19/9/2001 to 26/6/2009. Page 175.
Lordship. Lordship, the petitioner was working in the same time because, Lordship, I have read just now the date in which he was sent.
Because one Sufia Khatun was working from 2001.
Lordship.
Right?
Lordship. That I have stated clarification in paragraph 44, Lordship, page 37. Page 37, Lordship. I have clarified the entire thing, Lordship. Page 37, paragraph 44, Lordship. Lordship, at the initial stage, 2 teachers were there, Sufia Khatun and the petitioner, Ahedul Hussain. Thereafter, her services was provincialized, but his services was not provincialized due to the.
When was his services, Sabina Chaudhry's services provincialized?
Lordship. Lordship, page 85, Lordship.
In continuation of so-and-so, services of so-and-so, provincialized with effect from 1/1/2013 against the allotted vacant post as inserted in the so-and-so expenditure so-and-so. So one post is already filled up, Hindi teacher.
Lordship,
So-
he's working and one post is, Lordship. the
There are
dispute
2
is
posts
here.
of Hindi
There are 2
teacher.
posts, Lordship.
Where is the sanction order of 2 posts? The 2 posts of Hindi teacher was sanctioned. Where is that? Where is that sanction order of 2013? under the 2013 Act.
The teaching staff details their.
No. Sanction order. There has to be a sanction order.
The particulars I have annexed, Lordship, particulars of eligible employees.
I'm not on that. There will be a sanction order. That these number of posts and these are the persons who have appointed. First, it will be this number of posts allotted.
Lordship.
Then it will be these are the persons appointed. Where is that order?
That I don't have here, Lordship, but I have the particulars of the eligible employees.
That will not do. Where is that particulars?
Lordship, particulars is page 82, Lordship. 82, 83, and 84, Lordship.
82, 83, 84. These are the particulars
Particulars of
pertaining to.
eligible employees, both of the names were there, Safia Khatun and the petitioner.
Hey, you can't do options. Education manual. Education. Education manual.
Lordship, the Assam Venture Education Institution Provincialized Services 2011, section 4.1 covers my case, Lordship. Regarding 10 years continuous service and on the basis of seniority. Section 4.1 and 4.2.
This is a, what is the nature of this school? High school?
Lordship.
Huh?
Lordship, Anchalik High School, Lordship.
So only one post of Hindi teacher. Come to the provisions, page 664. How many classes are there? 6 classes.
Lordship, 6
Huh?
class.
Then there will be 2. Okay. So now you have challenged this order. Page 16.823 before this court, in this proceeding.
Lordship. Lordship, the impugn order rejected both of our claim for provincialization. The grounds I have stated, that is the ground for my rejection, and his rejection was that he produced a
So,
fake order.
your case we will consider. Why this review?
Lordship, the review, Lordship, the same order, Lordship had passed an order for.
That is with regard to him. He'll have to go. You can't stop him from going to the tribunal.
Lordship.
Can you? Can you?
No, Lordship.
Then
Lordship may therefore set aside this order and then let them take a decision and
no.
because this order rejected my grounds and all these grounds have already been decided by this honorable court.
So
earlier.
it's open for you because it's open to you. Now you can take this grounds before the learned tribunal. That is enough.
The same issues they were raising again and again to
That's why we send it back to the tribunal.
again, it will take a long period of time. Already
That cannot be the ground.
various rounds of litigations, Lordship.
Order dated 16/8/23 impugned in the present proceeding shall be subject to final declaration that would be finally passed by the jurisdictional education tribunal. And we have noted that both of you will be given due opportunity. Have you instituted proceedings? Have you instituted proceedings before the tribunal? Have you instituted?
Copy of the review petition is not yet.
No. Forget the review petition. Have you instituted proceedings before the tribunal?
No, Your Honor.
Why? Why? So because of this order, now you are also not allowed.
Sir, every time they have rejected my ground setting something or the other. But genuinely, the petitioner is working since the initial.
Where
date of
is that
appointment.
name of Abdul Qadir here in this 82, 83, 84?
Lordship,
82, 83, 84, where is Abdul Qadir? Abdul Qadir is what teacher? He is just a general teacher.
Lordship, his appointment order is at page 66, Lordship, of my writ. He claims to be appointed in the year 2009. Admittedly, Lordship, I am senior than him, Lordship, because I am working since
60,
2001.
60, 60.
60, Lordship.
60 is something else. It's an order.
Lordship, page 60 of the review, Lordship, that.
So he also claims to be a Hindi teacher.
Lordship, but his appointment letter is of 2009. Mine is of 2001.
So your appointment is already upheld by this court. That is your case.
Lordship,
Then give him a copy of the review petition.
Lordship, I'll survey my copy.
We'll pass orders, don't worry.
Okay.
But he will have to go before the tribunal.
Okay.
And in the meantime, if we can accommodate you in that post, we'll do that. But get me that sanction order. Right?
Okay.
Heard Ms. A. Talukdar, WPC file. Heard Ms. A. Talukdar, learned counsel for the petitioner. Also heard Ms. You are appearing for the secondary education. For the secondary education, the learned study council, secondary education department. And also Mr. You are not appearing. Are you appearing in the writ petition? No.
Petition, item number 7.
You are appearing
Yes, sir.
for respondent number? He is for respondent number?
4, in
Four.
item number 7.
Your name? S. Pegu. लिखी लो बस as diffusion learned counsel for the respondent number 4 also very strict to list this matter again on 18/6/2024 along with review petition number 85 of 2020. Reviewed Mariban. Ms. A. Talukdar shall furnish a copy of the review petition to Mr. Learned counsel appearing for the respondent number 6 writ petition. He was the writ petition.
He's respond number 4, Lordship. In the writ petition, he's respond number 4.
No, his writ petition. He was the writ
Writ
petitioner.
petitioner in the review.
Respond number 4 oblique writ petitioner within the course, during the course of the day. Also, list this matter also again on 18/6 along with WPC number 6786/2023.
Much obliged, sir.
Come prepared on the next date. Review, not very inclined, but the writ petition, the material she has shown, I think we will have to pass some orders. Right?
Lordship. Much obliged, sir.
But you will have to go before the tribunal. We will protect you in the meantime if it is possible.
Supplementary course list orders item 27.
Typographical error. Sorry for that. Heard Mr.
S. Paul, your lordship.
S. Paul, learned counsel for the applicant herein and also Mr. S. Roy, learned CGC appearing for the respondents. The present interlocutory application has been filed praying for correction of typographical errors that has kept in to the order dated 22/3/2024 passed by this court in WPC number 5833/2013. Full stop. Only in paragraph 5,
Yes, your lordship, only in paragraph 5.
full stop. The the applicant contends that in paragraph 5 of the check up whether any other error
I have gone through your lordship, only in paragraph
Five.
5.
in paragraph 5 of the said order dated 22/3/2024, the date of death of the son of the petitioner has been recorded as apostrophe date 18/6/2011, whereas the same should have been recorded as 18/6/2012. It will appear apostrophe date. Full stop. The date admittedly, the date 18/6/2011 as recorded in paragraph 5 of the order dated 22/3/2024, it was after order, is admittedly so and so is erroneous, and accordingly the same is calls for correction. Full stop. Subpara. Accordingly, the date 18/6/2011 apostrophe as figuring in para 5 of the order dated 22/3/2024 in WPC number 5833/2023 shall 2013 shall now be read as 18/6/2012. Full stop. For all intent and purpose. Full stop. This order would form a part of the order dated 22/3/2024, and both the orders be read together. Full stop. With the above observations and directions, the interlocutory application stands disposed of, right? Nothing more. That's the only thing. Only one 18/6/2011.
Only 18/6. Oblige, your lordship.
Delhi Coast List, hearing item 8.
Since as my lord, we were both praying for day after tomorrow if possible. Have some time, the part had matters. Otherwise, my lord, what had fallen from lordship is two things. My lord, one, what was he doing in Guwahati when he was suffering from TB in Nalbari? That answer I have, my lord. The second one was the eosinophil ratio. I tried going through the net all throughout, my lord. Usual medical opinion is that eosinophil ratio would not in any manner determine or not determine the
It's not that
presence of-
your eosinophil ratio, if you have such a severe infection, your eosinophil ratio will not
Madam,
be
that-
within the normal
But,
parameters.
what I have just read, my lord, I have not.
Anytime you have a cut in your hand,
It increases because. Well,
that is the defensive mechanism.
That is also what I tried to go through. The eosinophil, my lord, it is the sedimentation ratio. The eosinophil sedimentation ratio is what is found out in the ESR. Now, when we have an injury or something, and the blood vessels, they get some weight on them due to either the infection or some body reactions, they settle more quickly. Now, in case of a tuberculosis part, my lord, what I can also.
I'm not a doctor.
Even I'm not, my lord, but what I have only found is that eosinophil ratio at times increases, and in certain tuberculosis patients, it is found not to have increased. That is there, therefore, my lord, we will not, what I was proposing is not going into that. If lordship would go into whether he has an opportunity, he has some explanation for his absence, and whether that is required, that was required to be.
No,
taken
if you
into
can
account by the
establish
respondents.
your tuberculosis thing,
My lord.
naturally 18 months automatically comes.
My lord, what happens is the certificate, when I inquired from him, he said that.
Do you want to do it?
No, that I was.
Then forget it. Yes, Mr. Gogoi.
My brother will discuss more regarding MBBS partners.
No. He'll confuse. And that is normal. Mr. R. Mojumdar, learned counsel for the petitioner, submits that the matter, that he be accommodated for the day and the matter be taken up on any date after a week. Full stop. The above prayer is not objected to by, or shall I read the above prayer cannot be objected to by. The above prayer is not objected to by Mr. A. Gogoi, learned CGC, appearing for the respondents. Full stop. Accordingly, list this matter again for further hearing on when? On 18th. 18th.
I'm obliged.
Only on that, take me out from that, I will come in your favor. That certificates.
That MBBS part, my lord, I was once told from someone, my lord, it came that once you go into a particular aspect, you have to know all about it.
And don't give it back to that same person.
Since the issue is not one of law which has now fallen, it is taking me 4 days time.
Now we are a green coat. You see, we have birds also.
I noticed.
এইটো ওলাই দিব নোৱাৰি নেকি কিবাকে? এই দৰ্জাটো খুলি দিলে যাবই। এইটোও খুলি দিয়ক। নাই একো কৰিব নালাগে।
They are blocked by
Fans and on কৰিব
exhaust
নালাগে।
fans.
এইটোত সোমাব দিব নালাগে।
These doors are blocked by exhaust fans, so.
এই দৰ্জাকেইটা খুলি দিয়ক না।
No, they have exhaust fans there.
Exhaust আছে নেকি?
Exhaust fan in nets. I don't think so.
Anyway, let him be. Let him be. Maybe he is also have some past life connection. Huh? That's it. He might be having some.
Lordship.
Like me pursuing MBBS. Obliged, my lord.
Unfortunately, this file went back to this section, did not go with me. So I could not pass. I was searching for this when I went to Arunachal. I could not.
One thing, I will submit the odd instruction which provided by the second, that will be quoted in the order. That will be
Will try.
better,
Will try. Will try.
because otherwise,
Heard the parties at length. Hearing concluded. List this matter again on 18/6/2024 for delivery of orders. A file to move delivery. I'm sorry, this file went back to this section. Your written arguments were with me. But this thing was with me, but the file was in the section. It did not go along with me, so I could not pass. So I'll pass the orders on 18th.
But
You are appearing for?
um,
15 to 22. ভাঙি দিব ওলাই দিব থাকিব নোৱাৰি ইমান অশান্তি পাইছো
Lordship, my senior, he is coming,
Oh.
is someone.
If he comes, he comes. Otherwise, let him be outside.
my-
Ask him to. He's roaming around. I know that. Call him.
Yes, Lordship.
my lord, my lord, in this case, my lord, Mr. D. Majumdar, additional AG is appeared.
That we know. But let's hear what they have left here in this case. 2013, last 10 years, 11 years, there is no problem.
As I have understood, my lord, so he is to, they are to challenge that section M4 of amendment, my lord, 2020.
That they cannot.
Is to challenge that amendment.
No, they have not challenged that here. Yes.
I'm sorry, my lord.
What is left here?
My lord,
What is left in this proceedings?
no, my lord, first of all, I have not been in touch with the clients.
Forget it. We'll close this.
Too long, my lord. And I need some time to prepare if I have to argue. Lordship will take it up.
2013 matter,
Day
we're not
after
arguing. We'll
Day
give you
after-
time till 2 o'clock.
My lord will take
2
it up
o'clock. 2 o'clock.
day after tomorrow.
2 o'clock.
It will be harsh, my lord.
It won't be harsh. It's 2013 matter.
I understand.
It would tell on me if I adjourn this matter.
I understand, my lord.
You argue. What is it?
My lord, day after tomorrow.
See, show me where is the material on record in the writ petition to show that the criteria that the government had determined for segregation of the villages was not applied in case of Posimudi Dhuli, village name Posim Dhuli. Tell me that, show me that. Then we'll go to the other matters. Simple as that.
Well, I'll come up with preparation on the day after tomorrow. At least I need to justify with my,
2013 matters, what were you doing?
I apologize, my lord.
No, you need not apologize. I've been going through yesterday night. If you were not in a position, this list came out day before. If you were not, you could have told me. That's not today, tomorrow. I could have taken a leave today because there is no matters taken today. So only on that aspect. That is the criteria, not challenging the rules.
Yes.
Rules are not under challenge here.
Yes.
Then
Malam, section 4, 2001 amendment, Malam, is to challenge. So
Yes,
long
Mr.
that stands, Malam. So
that's what my question is. Then they'll have to show now the criteria is changed from Rabhas and to scheduled tribes.
to schedule.
Then-
And so long, my lord, section 4 of the Rabha Council Act stands, my lord.
They cannot.
My lord, they cannot.
Amendment. Okay, where is that amendment? And only fear that you have expressed in the writ petition is that once this comes within that tribal area, you will not be permitted to sell, buy land. But if you are an original inhabitant of that area, why do you have fear? Because you are protected. Under chapter 10, you are protected.
Well, till tomorrow, my lord. Tomorrow. I'll come up with at least
No,
let
no,
me have
if
that.
Mr. Das and Mr. Thor permits.
If they permit,
Maybe.
they'll
Ah.
not object to me.
You are under his influence.
Because he is to challenge. That is our prayer.
No, he is saying that you will not object him.
My lord,
Such confident statement he is making.
my lord,
No, he will not object. Well, issue is small. He will not
very
object.
small that by tomorrow, he can file a retake it. He can always, tomorrow, my lord, he can file an appeal. He can-
Section.
No, he'll have to file a writ petition.
My lord, what my respectful submission, let me examine tonight. If I found that yes, it has to be challenged before a division bench or that particular section has not been challenged is the petition.
How can you challenge here in this
No,
writ
no, what I am
petition?
trying to say is, if there is a mistake on my part or some lacunas are or some drawbacks are there in my petition, I will withdraw this case tomorrow. I will not trouble your lordship.
You did not. Others I know, I'll pass orders. Your only plea here is 50%. And that
Yes,
has changed.
50%.
That dynamics have changed from a particular community to ST as a
No,
whole.
no, my lord will appreciate.
No, I can't appreciate because that is the act. Section 4,
To declare something under the, bring some particular area, some pocket or some satellite areas to come under the council, it has to have more than 50% predominantly of that community.
no, that is the difference here. It is STs, not a particular community. That is the amendment. Where is that act? Amendment? Amended act. We'll finish it off now only. Wait.
Their contention is only Rabha.
Your case is structured on the concept that we don't have a village, our villagers don't have a population of 50% of Rabha community. But that has been done away with. Each, in the preamble of each having more than 50% so-and-so, 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 so-and-so shall be substituted. Another having more than 50% tribal population. That is the difference. So-and-so, there shall be for each of the block of each village having more than 50% so-and-so. The words, there shall be village council for each block so-and-so, irrespective of population pattern therein, each having more than 50% or more tribal population.
All, my lord. It includes all, my lord.
Mr. Chamua,
My lord.
you have this act, you may not have it. We'll have it at 2. Just go through it. And thereafter read your petition. You need not read, you only smell. Do you read? You don't read. So wait time. Go. 2
Today's
o'clock.
quota is over.
Huh?
Today's quota is over.
Quota is just begun. Yes, Mr. Doc.
Yes. ma-
He only takes 2 minutes. I don't know.
Item 23.
আমার affidavit of the-
I wasn't in the last. Yes, Mr. Ghosh.
In this case, my lord.
Yeah, your junior asked for some time. He wanted you.
Some instruction in the matter.
What instructions do you want?
Because my lord, he has already applied for, I am told that BCom course also, my lord. He has already have the BA. So my lord, even the multidisciplinary, this include BA plus BEd, my lord. So this will perhaps, if I get that instruction, I can bring it to the notice of lordship by.
How will it change the dynamics of this game?
Yes. Otherwise, my lord, my case was rejected on a different ground for non-submission of certain document within the specific time limit, my lord, against which I preferred an appeal. Then my appeal was dismissed on the ground of delay, my lord. Then we approached this honorable court. The honorable court remanded the matter to decide the matter on merit. So my lord, while deciding the merit, they decided and rejected my case on the ground of a NEP, my lord, a policy decision, which was not
Not even applied.
original ground of rejection by the ERC, my lord. Not it is a ground before the, my lord, appellate authority, my lord. They altogether brought a new ground, my lord. My lord, which is not tenable, my lord, because I have not.
By when can you get your instructions?
My lord,
This week? Thursday?
Huh?
Thursday? Tuesday?
my lord, next weekend, then, my lord, any.
Tuesday. On the prayer of Mr. B.J. Ghosh, learned counsel for the petitioner, and not objected to by Mr. A. Alam, learned standing counsel NCT, list this matter again on 13/6.
Because, my lord, what is my subject to your lordship's correction? Perhaps, my lord, the matter may be remanded to the appellate authority.
No, we'll have to remand after holding that what they have said is not correct.
Yes,
So that I'll have to hear it.
my, oblige.
Take good disposal. Irrespective of the percentage, that village will be counted. Now, there is no material to show that your village is not in an area covered by the tribal supply. That's all. And the affidavit that they have filed, you have not responded.
They do not have filed. They have not filed.
No,
Government has
there
not
are affidavits here. There are affidavits here.
filed. In which case?
In
3745.
in 3745, there is an affidavit.
Affidavit by the DC,
DC,
not by the government.
no, forget it. DC has said in para 10. Come to para 10, page 3. That with regard to the so and so Bexus said so and so falls within Saigaon revenue circle under DC and has been included on the ground that the village is within the tribal subplan area. Now, this you yourself say in your writ petition about this amendment.
So that's correct, Miller. I was, while filing the writ petition, I was aware about the amendment in 2001, 2005.
So only thing is that if that amendment goes, the subsequent amendment goes.
My lord, appreciate. In 2001 amendment, my lord, if I can take your lordship to the act, in 2001, they have amended in section 4, it says that the word Rabha community should be replaced by
ST, scheduled tribe.
scheduled tribe. But the fact remains.
No.
No,
There is a further amendment, 2005.
Huh.
2005.
What it says, my lord?
It says, come to DD, your page 7. DD, core areas.
Core areas means the
Compact and contiguous are
areas.
predominantly inhabited by so and so, above whole, as a whole in the area, not necessarily in the individual villages.
That's
Trying to
what I'm
give
saying, Lord. That's what I'm saying. If I'm included in, if I'm in core area, census record says this, some areas or some villages are there where ST people is 0 even.
we can't help it because that is not, they have not made it a unit, a village. They have made it an area. In that area,
That
so
is, that is what I'm saying, Lord. This is.
you have, the example that you have given is with regard to a few villages. We don't know whether this core area means 5 villages or 100
If your
villages.
lordship comes to, if your lordship, if I have rightly understood, lordship says, the meaning of the core area means, as your lordship now explained, my lord, as I have understood. That suppose village A, B, C, D, E. In cumulative total of this A, B, C, D, E is more than 50%. Irrespective of one village is 0 in ST community. Then also it can be declared as a tribal subplan area.
You come to satellite areas.
Yes, ma'am.
Means
Satellite
area or areas consisting of non-contiguous cluster of villages predominantly inhabited by so and so, having 50% and above as a whole in the cluster, not necessarily in the. Now we don't know what is the cluster they have taken.
That
It's
is
not here.
This is where they should have filed an affidavit detailing that this is the cluster. They should have declared, they should have said, asked that this is the cluster. Within this cluster A, your villages comes into, that is why your name.
Now show me from here whether you have, what about this paragraph 10?
Of my petition.
No, of the affidavit.
Yes.
Categorical statement, tribal subplan.
So what is tribal subplan? That has been, they have to declare, my lord. They have
You have
to-
not contested this statement, Mr. Samoha. This paragraph 10, you have not disputed.
My lord, my whole case is that, and they have admitted my arguments. They said you are within the tribal subplan area. We said that you cannot bring me into. the
Then
tribal
you will
subplan.
have to challenge that provision. You will have to challenge that provision. Once that provision is holding the
My
field,
lord, declaration of tribal sub, I have challenged the declaration of tribal
Mr.
subplan.
that is the criteria under the act. Now, if that is the criteria, maybe in an appropriate application, if you challenge that, the criteria, we will interfere. But here, it's not there. The act is holding the field.
My lord, be that as it may, but they have to have 50% of the tribal community.
I'm not on that. If they say tribal subplan area, not within satellite and core, two things.
Huh.
If you don't come in core, you come in satellite. And satellite is non-contiguous. It can be a large Rabha council, we
That
know.
means tomorrow, if the government declares Panchi Bazar as a satellite area for,
But let them do it if the act permits that. If the act permits that, let
That
them do it.
means Rabha Hassan Autonomous Council can declare one.
You tell me,
area in the
Rabha, you know, we know 6 scheduled areas in the state. Bodoland area. We'll take that's a classical example. It is otherwise an area, contiguous area.
Continuous area.
Contiguous area, continuous area. Whereas Rabha and the other community autonomous bodies that have been created, it's not contiguous. It is not continuous. It can be a village here. The next
That is
village
what the
might be.
Concept of satellite area is.
That
what
is
the-
why. And if that satellite area, your village may not be, but if it comes within that zone, why will it not? That is I'm not on, they may have made a mistake. But the question is, once that power is given to them and that power is not questioned, if the act says you can do it, how can the executive go beyond the act? And how can this court consider a delegated thing, identification, when that identification relates to the provision of the act? Yes, Mr. Thor.
Yes, my lord, unless he challenges the act, my lord, the provision of the act, my lord. My lord, this writ petition cannot override the act, my lord.
What were you doing from 2013, not pointing that out to this court?
My lord, I repaired for the first time, my lord, this morning only. That is the first thing I saw, my lord, after opening the file. That is what my lord, shared with my friend, my lord.
Will not put Mr. Samoha to trouble. Many villagers may come chasing him after this. So we will give him some time. We'll have this matter. Today is Tuesday. We'll have it on Thursday.
What?
Thursday. But
Thursday is not
Sixth.
6th,
6, right.
we'll have it as the
Mr. Dhar
first.
may go for swearing ceremony. that
Huh?
is. Mr. Dhar may go for swearing ceremony. That is what.
No, Mr. Dhar is beyond that. He'll only go for his swearing ceremony, not for others.
My
Welcome,
lord,
welcome.
my lord, just reflect my name in the corporation.
I'll do that. Heard the parties at length. Full stop. Hearing remains full stop. List this matter again on 6/6/24 for further hearing. Raised it to reflect the name of Mr. R. Dhar, Lanet.
What's it? Respect is a part heard, my lord.
R. Dhar, Lanet, Standing Council for the
Tribal affairs. Now
Tribal Affairs Department. Now that is PN, that what you called earlier,
WPTN, my lord,
is not there. So you get me the concept of tribal supply on Thursday. Explain the concept of tribal supply. Just explain and give me a copy of all the amendments, act and the amendments. If you have it, you can give it to him. That will help me.
The soft copy I have given her, but it's
So,
too large.
copy, do you expect the High Court to? If you want it, you give me, otherwise I'll not go into it.
I'll-
Tribal supply, just explain. Otherwise, we have,
Otherwise, the case is clear, my lord. It's this point only. If it can include a area which does not have even a single number of.
see, the appreciation level of Mr. Chomuha is very high. But don't expect that high level appreciation from this court also.
I don't know. I
We-
know
we-
it is
we-
not a
we-
compliment.
We don't understand things.
I know it
We
is
try
not a
to.
compliment, my lord.
If
I'll
you
try
don't,
to
if you
satisfy
can't
you.
take a compliment, I can't help it.
I'll satisfy your lordship.
And what is your stand?
Because this is amendment, Malad. He has to challenge it before the.
Why? Why should he challenge?
Because
If why, show me how is it a tribal plan? You are appearing for whom? Government? How is it covered? How is the tribal sub-plan applied?
Again,
13 onwards, you are not there. What is this affidavit? Tribal sub-plan applied? How it is it applied?
Government has not yet filed.
You hold it. How is it applied?
because, yes, Malad, we have not explained in the.
Ah,
affidavit, Malad. We have not explained.
Get me materials.
Okay.
Otherwise, we will exclude all these villages. It's only now how you apply satellite area and core area. Core area may not come in, satellite area may come in.
Fine.
So how? What is the idea behind it? Mr. Dhar, both of you.
My lord will fix the matter. Not the after, my lord, because of this election results. I don't know how much.
No, forget it. You're that high level, you need not talk. You talk to your bottom level officers, they are always there. Thursday.
I told you.
13 matters, no adjournment.
Well, I'll come on 6.
If you don't come, we know how to get you here.
I assure you, lord.
We know how to get you here, don't worry. India matter, seriously matter. Soy ke diche na? Soy try ke diche. Soy. Apne slip out pathai dibo. No, pasta ke diche. Yes.
I received the
My lord,
record.
uh,
And lordship record reveals that the
Where
proposed
is-
notice was issued on 16 August 2018.
Hmm.
They have not submitted any reply and adjudication is pending also. And lordship further,
Now, what is the satisfaction drawn there with regard to reasons to believe?
yes, lord. In our affidavit, lordship, we have.
No, I want from the records.
pledged-
You tell me, Mr. KL is there, why should I apply my mind? You will tell me. That is the starting point. That has to be the first thing which has to be thrust out. What is the,
Probably this question will not come in this case.
Why?
Because the facts of circumstance of this case, because the roads were seized on the airport.
and this material, is it suspected to have come from some other foreign country?
Clarification was issued, but they failed to satisfy that authority. So they waited, lordship may please to see.
No, just see how this order was. Madam, that is the first thing that has to be done.
that's
My
why-
limited knowledge, I think that is the first thing we should.
that's why I have just now prepared a chronological list of
Hmm.
dates about everything what has happened till date. How, because the matter went into CAV, then the proceedings were not done by them also. They also did not issue any notice after 2019. So where is the question of participating in that? That till 2018, the proceedings were going on, we participated in that. And the statement was also recorded of both the persons. So because this matter was sub judice, that's why the things did not went on, because then the petition will become infractuous, my lord. If they come to a finality, I have just challenged the search and seizure. My petition will become infractuous. He had given a verbal assurance also before.
This court that they will not do it.
That they'll not do anything because the hearing is in the final
Okay.
stage and matter.
So we only have to got to examine if the Caesar and
Reason to believe was.
believe are fine, then that the rest of the
Yes.
proceedings, it's up to you.
Yes, yes.
So satisfy us on that.
Let her complete.
No. Well, from your records.
Lordship may first take my affidavit. also.
We'll understand it slowly.
Or lordship may go through the proposed notice. Everything is.
No, you tell me. So your thing is, although it was done, seized, and he had declared that he was an employee of a shop here, but you still had a doubt that although it was very far away from the international border, you still had a doubt that this would have come in from some smuggled goods, literally. Now, what is the material to satisfy, to draw that satisfaction? Have you examined the route which the person had taken?
Question of route will not come in this case. Sir.
Will not come.
Yes.
Okay.
Approximately to, it will be paragraph 32 of Stockholm notice.
Just read it. Just read it. I'll go through it after I hear them. Just want a preliminary thing. That's all.
From the materials and facts of this case, it appears that Sri Sunanda Bhomik, who had concealed one Bengal weighing more than 330 grams in his left arm, for which he could not produce any document. On being asked, he produced delivery challan number so and so about 2017 in September and diamond jewelry, which was in his handbag, which is what mentioning here that he was carrying jewelry weighing more than 1.5 kg, all of which were kept in his hand.
So that is basically the material you have. His statements.
Such a will go. No honest, prudent man would attempt to conceal such the obvious was not in support. God is the weight the authority by concealing same in his arm. Moreover, in his statement dated 26/8/2007, Sri Sunanda Bhomik stated that he wore the gold strip kada in his left arm to conceal it, avoid detection by anyone. This is act of Sri Sunanda Bhomik points towards the malified intention of illicit procurement, transportation, duty evasion, etc. in respect of seized gold and bangles. Next paragraph, from the examination of observed that none of the challan were GST compliance. It is absence of details of receipt and purity, value, and other mandatory details as prescribed in invoice rule GST Act 2017. This act of the consignor proved that intention of tax evasion and point towards the illicit nature of good. Then paragraph 3, Sunanda Bhomik stated that for Mr. Manikchand and Sons Jeweler Private Limited, Guwahati since 2015 and was paid rupees 2,000 to 3,000 yes. Also, that he is not an employee of Messrs. Manikchand and Sons Jeweler Limited, Guwahati, and have any defined of service, the authorization or contact Guwahati. He just carries transport goods, but in general, he takes the goods with him to his house, and after getting instructions from Sri Kishanlal Soni, he delivers the goods to final. Usually, he delivered the goods to the persons concerned in roadside and not in any business establishment. Similar
Okay, done. Got it. Yes, madam.
My lord may kindly come to the teaser notice that they have given for seizing the goods at page 34 and extra 5.
This is dated
Date 1/9/2017. This is dated 31st 8/2017.
31.
8/2017.
Caesar.
Lordship may kindly see point number 5, the reasons for seizure. They are improving their case every day, my lord. The reasons for seizure, may I read, lord? Illegal importation into India through a route other than those specified under Section 71C of the Customs Act 1962, violation of Section 11 of the Act, and notification issued thereunder of the Customs Act 1962, read with the provisions of Foreign Trade Development and Regulation Act 1992, including the orders and rules made thereunder, as amended as made applicable to the Customs Act 1962 under Section 3(3) along with the provisions of GST Act 2017. Now, my lord, just now he said that we are not concerned with route in this case. But the first seizure notice that they have given that
That is why I asked it.
he's improving his case every day. Now, lordship will come below. Lordship will see details of goods seized. There, lordship will see point number 5. Mixed gold studded gold ornaments, diamond ornaments. These are old and used ornaments, lordship.
And they themselves admit that.
And and the part of ornaments and the above 4 gold bangles also in their statement, Sunanda Bhomik, as well as that person of Manikchand who had appeared before them. He has again and again said that these were only for cutting and polishing, and they put some material inside. No, when the bangles are new, they have to put and round off that bangle so that it is comfortable in wearing. It's only for those repairing purpose.
Now tell me one thing. This actual seizure or
Yes.
the actual detection occasioned on
On 26/8.
26/8,
Yes. Actual detection took place on 26/8,
2017.
2017.
Now, at least by 28th, you had given maximum documents. Now, what was the requisite? What was the necessity? How did you come to this conclusion on 31/8 when you made this seizure that these materials are there, which you are satisfactory, reason to believe that these are smuggled goods?
No, Lordship, what happened? Initially, this was the reason to believe.
Hmm.
But subsequently, when the investigation progressed, these things were.
And somewhere I found that they have also given, they say that these are of their customers.
Yes.
But they failed.
Now, they have given affidavits of the customers also. Have you taken into note that those things?
If the investigation is not complete at that relevant.
No. I'm
Yes,
only on the question of reason to believe.
Yes, Lordship.
What is reason to believe, according to you? Okay, fine. Mr. Kal, you take your seat.
Only one more. Then next page, lordship will find annexure 6, which is their reason to believe now.
Okay, yes.
They come to some other conclusion, lordship. And this is after the seizure, after 31st date. 31st date, 1/9/2017. In the aforesaid case, the possessor, Shri Sunanda Bhomik, was found concealing so-and-so gold kara in the left arm and also found carrying gold and diamond jewelry in his handbag. The possessor produced delivery challan so-and-so. So delivery challans were there with him. One delivery challan which was not there with him, that was also given later on. The possessor produced delivery challan both so-and-so in support of gold and diamond jewelry, but could neither produce any document in support of gold kara, which was concealed in his arm, nor could provide any satisfactory answer in this regard. It is observed that even after passage of 4 days, no one, including any authorized persons, representative so-and-so, in support of purchase, possession, sale, transportation, job work of the retained goods, thereby pointing towards the smuggled nature of the goods. Further, it appears that consignor is adopting delay tactics to tamper with the evidences and hamper delay the verification process. Moreover, delivery challan so-and-so submitted by Sunanda Bhomik on 28/8/2017. So the third delivery challan that was also submitted to them before the seizure, 28/8/2017. And that they say appears to be manufactured after thought. So further non-declaration of the lordship will see further non-declaration of the exact destination, address and other details as per Rule 10 of the Invoice Rule GST Act 2017 hints towards the smuggled nature of the detained goods. What is GST to be do with the smuggled goods?
When did GST come into force?
I have no objective. 1/7/2017. So they have said we have default, the invoices are not according to GST Act. Now the belief where from it comes. The numerous seizures of gold in and around Guwahati in the recent past, combined with the intelligence input, suggests the modus operandi of operandi of changing the original form of gold into various ornaments and use of dummy documents for transportation of smuggled goods points towards the illegal nature of the detained goods. So from the above stated combined facts and circumstances, events of detection forms and reasonable belief that the goods in question are illegally imported into India through a route other than those specified under Section 7(1)(c) of the Customs Act. Violation of Section 11 of the Act evid and notification issued under the Customs Act 1962 read with the provisions of the Foreign Trade Development and Regulation Act, including the orders and rules and so, and with the provisions of GST Act 2017, thereby rendering the seized goods to confiscation under Section 111 of the Customs Act 1962. So the reason is that we will evade tax. Revenue to the government will not be given, Lordship. That cannot
Customs, that will come.
smuggling. And smuggling, Lordship will see one more thing. This petitioner, he's a businessman in Guwahati for last 70 years, 80 years. After this seizure, he was so much shocked that the person died in 2 months. The main person, the head of the organization died. Mr. Manikchand died in 2 months because he was so shocked with the incident. We have to move a bail petition in his regard. He was 70 years old. We had to move a bail petition, take his bail, and then he died immediately. This sort of harassment was done. And what they have no proof and they have afterthought.
Now, what is the ground here to have that reasonable belief in this?
They have taken GST. We have not given proper challan because when the goods are
If I've understood this thing, that their contention is that because the invoices that you have given
Yes.
not being GST compliant,
Yes.
so there is a doubt that you have manufactured this to
Yes.
just show the ownership.
But they have to understand one thing. In the regular course of business, when I am sending from my organization to my or
It will only be a transfer.
we will just transport that. We have to just keep an accounted for. Goods should be accounted for. In seizure, there are 101 cases which says if the goods are accounted for, then you cannot seize them. There was the account of the goods that they cannot
Okay.
deny.
Okay, one question.
Yes.
Just a practical question. Now you have produced here, somewhere I saw,
Yes.
the certificates are here, page 40, 45 onwards, right?
Yes.
These are documents which you gave to Sudananda Bhaumik
Yes.
just to cover up the gold which is within.
Yes. It should be accounted for. Like what you
Accounted.
said.
Okay, fine. This is the copy delivery challan which you gave to that man.
Yes.
Did you retain a copy, similar copy in your official records also? Was that inspected by the custom authorities? Was there any such made in your instance? Why?
But they asked us to produce, we produced again copies.
The records you have produced.
Yes. They asked for copies, we produced.
Okay.
We even submitted a reply to the show cause also.
That we have seen. Now take me, this is the issue, first issue.
First thing.
Now show me the sections involved.
Yes.
Customs Act rules.
Yes. And Lordship, I'll like to place before your Lordship their notification which they have relied on in their affidavit, which says that the reasons has to come before.
Before.
Hmm.
Is it a situation that they will assign the reasons and then make decision? Is what
Yes,
the law?
Yes, but Lordship, this notification says that on the same day. On the seizure day, they have to
Disclose the reasons also.
disclose the reasons along with the seizure order. Lordship, point number 4. In this also. In view of the above, in all future cases, the following may be adhered to. Whenever goods are being seized, in addition to Panchnama, the proper officer must also pass an appropriate order, seizure memo, order, etc., clearly mentioning the reasons to believe that the goods are liable for confiscation.
Okay.
And Lordship, in this notification only, there is a time limit for issuing show cause notice. They are telling that we are not cooperating. even we have cooperated with the investigation. They wanted extension of time. We have cooperated with that. If we were to run away,
That I saw in your, that list of dates. you have-
yes, we have cooperated with that also. We said, yes, you extend the time. We are ready to cooperate. So we have tried to cooperate with them in every way. I don't know why they're saying that we want to run away from the investigation. Lordship will kindly come to 110, Lordship, section custom of the Customs Act.
110.
Yes, sir. Seizure of goods, have you Lordship?
If the proper officer.
Yes, seizure of goods, documents and things. If the proper officer has reason to believe that any goods are liable to confiscation under this act, he may seize such goods, provided that where it is not practical to remove, transport, store, or take physical possession of the seized goods for any reason, the proper officer may give custody of the seized goods to the owner of the goods or the beneficial owner or any person holding himself out to the importer. Here also the word is importer, Lordship. Everything in the Custom Act evolves around importer, exporter.
That's true, because customs is for something, transaction taking place
Place
outside the bound,
outside
from outside the boundary of the country.
Or any other person from whose custody such goods have been seized. On execution of an undertaking by such person that he shall not remove, part with, or otherwise deal with the goods except with the previous permission of such officer. Provided further that where it is not practical to seize any such goods, the proper officer may serve an order on the owner of the goods or the beneficial owner or any person holding himself out to be importer or any other person from whose custody such goods have been found, directing that such person shall not remove, part with, or otherwise deal with such goods. Lordship, the first two lines is only important, Lordship, in section 110, which says that if the proper officer has reason to believe.
Reasons to believe.
First, he has to reason to believe, and then only the seizure comes.
So what is this reason to believe? That
What
we'll
is
have to.
reason to believe, Lordship? Lordship, I'll take your Lordship.
There is a. Somehow I could not lay my hand on it. I read it. A latest decision. I don't know whether it is of a High Court or of the Customs Appellate Tribunal. Beautiful reasonings were there in this connection.
2023 judgment.
23, huh?
23 judgment.
Right?
Yes, Lordship, I have brought that.
Yeah, brought that.
Yeah.
It's of CGAT.
Yes.
Huh?
No, it's of a High Court.
High Court. Our High Court.
Not our High Court.
Delhi.
Delhi High Court.
That is the one which I read. Do you have a copy of that?
Yes.
Because it was, I never thought that it will be required for me. So I just read it and I left it. Yesterday I was trying to trace it out, but I could not. So this is the one.
Union of India versus Magnum Steel. I hope this is the judgment that Lordship is talking about.
No. Not this. I forgot whether it's of a High Court or a CGAT, but the reasonings there pertaining to this Caesar, beautifully delineated. 100, 110. 100 is also involved here,
Yes.
section 100, 110. That much I remember. I'll get it. Don't worry, I'll get it. Okay. Then what do you want to show?
After this, Lordship, I will take your Lordship to section 124. That was also not followed in this.
124.
Four.
And Madam, if we come to a conclusion that the reason of belief 110 is not complied with, then the whole proceeding goes.
Issue of show cause notice before confiscation of goods, Lordship. No order confiscating any goods or imposing any penalty on any person shall be made under this chapter unless the owner of the goods or such person is given a notice in writing. With the prior approval of the officer of customs, not below the rank of an assistant commissioner of customs, informing him of the grounds on which it is proposed to confiscate the goods or to impose a penalty. In this case, the superintendent of customs is doing all the work, Lordship. Inspector of Customs and Superintendent of Customs has been doing the whole procedure. So this notice also was not given to us.
No, this is subsequent. This is not the reason to believe.
No, this is not reason to believe, but I just want to say that the procedures also has not been followed in this.
Okay.
Lordship. And Lordship, the last thing is that section 7(1), which they have quoted in their Caesar memo.
Hmm. Mm. 7(1), yes. 7(1)(c).
7(1)(c), Lordship. May I read, Lordship? The routes by which alone goods or any class of goods specified in the notification may pass by land or inland water into or out of India, or to or from any land customs station from or to any land frontier. The Guwahati airport cannot be said to any of this, Lordship. This under this definition, Guwahati airport doesn't come, Lordship. Therefore, Lordship, what they are saying, what they are saying, that if Lordship takes my list of dates, Lordship, these are the sections which are not at all applicable, which they have applied, and they are trying to improve their case, Lordship. And if Lordship takes my list of dates, then Lordship will see that on 26/8/2017, the person concerned was checked in the airport. Then 28, the directors already gave a letter to them that saying that the jewelry are for repairing. 31st/8, the seizure is done. On 1/9/2017, the reason to believe comes after the seizure. Then we file a writ petition. In the writ petition on 22/9/2017, the goods were provisionally, the stay was granted. Then on 9/10/2017, the goods were provisionally released. 16/2/2018, they have filed the respondents has filed their affidavit. Then on 23/2/2018, the respondent prayed for extension of time for issuing show cause notice.
How was this prayer made? Oral prayer before this court?
No, they prayed before the commissioner of Shillong.
Okay.
There they prayed. We were also present, Lordship, because they wanted our consent. So we gave our consent. That is there in the IA which has been disposed of, Lordship.
Okay. Now you take me to that reason to believe. That's the
Yes.
crux. The decisions which you want to rely on that. I think all the decisions are here only.
Yes, in the compilation, Lordship.
Hmm.
The first one, Lordship, that is in page 15 to 24. In that, Lordship, I would like to rely on para 19, Lordship.
Compilation page.
Page 21, Lordship. The judgment starts before that. It's at page 15, Lordship.
It's a judgment of the Punjab and Haryana High Court.
Yes,
20.
21, Lordship. It starts at page 15.
Expression to expression.
Reason to believe has been interpreted in several decisions. In Income Tax Officer Special Investigation Circle B, Virat so and so, while interpreting an identical expression used in section 132 of the Income Tax Act 1961, it was observed. The section does not confer any arbitrary authority upon the revenue officers. The commissioner or the director of inspection must have, in consequence of information, reason to believe that the statutory condition for the exercise of the power to order such exist. He must record reasons for the belief and he must issue an authorization in favor of a designated officer to such the premises and exercise the powers set out therein, which I have showed to your, pointed out to your lordship in section 124. There has to be an authorization also. That also was not there in this case, lordship. The condition for entry into and making search of any building or place is the reason to believe that any books of account or other documents which will be useful for or relevant to any proceeding under the Act may be found. If the officer has reason to believe that any books of account or other documents would be useful for or relevant to any proceedings under the Act, he is authorized by law to seize those books of accounts or other documents and to place marks of identification therein, to make extracts or copies therefrom, and also to make a note or any inventory of any articles or other things found in the course of the search. Since by the exercise of the power, a serious invasion is made upon the rights, privacy, and freedom of the taxpayer, the power must be exercised strictly in accordance with law and only for the purposes for which the law authorizes it to be exercised. If the action of the officer issuing the authorization or of the designated officer is challenged, the officer concerned must satisfy the court about the regularity of his action. If the action is maliciously taken or power under the section is exercised for a collateral purpose, it is liable to be struck down by the court. If the conditions for exercise of the power are not satisfied, the proceeding is liable to be quashed. But where power is exercised bona fide and in furtherance of the statutory duties of the tax officers, any error of judgment on the part of the officers will not vitiate the exercise of power. So he has to prove that this power was exercised properly and not arbitrary use of his powers was done in this. Lordship, then next we come again, paragraph 20. The expression reason to believe is not synonymous.
You can come to paragraph 25 straight away.
Yes, Lordship, 22, 25, these also I have marked. Paragraph 25. We are of the view that while exercising existence a power of Caesar may be justified, but its exercise will be liable to be struck down unless reasons to believe were duly recorded before action of search and seizure is taken, which has not been done in the present case because the respondents have not been able to satisfy the court that due process of law was followed while taking drastic step of search and seizure in the case of the petitioner. On this ground alone, we are of the view that action of search and seizure is liable to be quashed, and accordingly we answer the second issue in favor of the petitioner and against the revenue.
Any Supreme Court judgments?
Yes.
Where? Yeah.
Next is the Supreme Court judgment.
Okay.
This is detention by CIF cannot be considered as seizure by customs on intelligence inputs, Lordship. This is on some other point. But then the next one, Lordship, I would like to take your Lordship to the next one. Reason to suspect is different from reason to believe.
Which one?
Reason to suspect.
Page.
Page 32.
30?
Page 32, Lordship.
That's there in the Punjab judgment also. That reason to believe and reason to suspect are both different.
So they had the reason to suspect. They did not have the reason to
Believe.
Lordship. In that, Lordship, paragraph 33, Lordship.
Calcutta.
Page 41, Lordship, paragraph 33. I have carefully considered the respective submissions of counsel appearing for the parties. I have gone through the records produced by the respondents in this court. I am very much candid to say the steps of the income tax authorities to make so-and-so block to get attracted an individual SSE and then proceeded for search and seizure is misconceived. Page number 41 of the.
I got it.
If the brand name so-and-so is taken for judicial notice, then whosoever is selling the product either in India or abroad under such brand name is to be assessed under the block. Flourishing of business under the brand name cannot be a reason to believe of evasion of tax. I am sorry to say that this is not the true import of the law. One cannot put the cart before the horse. Even requirement of block assessment ipso facto cannot be the reason to believe under section 132 of the Act. Section 132 has its independent face value. If one is attracted by such section, he can be assessed in a proper manner under the prescription of law. If one is not attracted under the section 132, then there is no question of any block assessment on the basis of search and seizure. Therefore, let me confine to the question as to whether search and seizure was made following the prescription of law or not. According to me, prescription of law about reason to believe in between the Income Tax Act and Central Excise or the Customs Act is different. In the cases of Central Excise or the Customs, reason to believe is the sole requirement. Reasons to believe is the sole requirement, my lord. But under the Income Tax Act, reason to suspect is also available, but subject to reason to believe.
Your case is that the reason to believe came subsequent to the seizure made.
Yes,
Whether that is valid or not, that is what we have to.
that's what we have to. And main thing was that those goods were accounted for. Once they are accounted for, there is no reason that.
Now tell me one thing. They had got this goods, Panchanama was made on 26
26.
itself. So they then offered you a chance to justify. So you gave them certain documents. That these are the documents, invoice bills. Sudan Bhumik had some was in his car, some you subsequently gave. By 28th, you gave these documents.
Yes.
Now, between 28th and 31st, they'll have to form an opinion that, see, we have reason to believe that these documents, these materials are insufficient, or that we have reason to believe that these are smuggled goods. So that reason to believe, I'm just trying to understand, will arise after the Panchanama is made, things are got, and within that, see, before seizure is made.
Before seizure.
Now, you had given them certain invoices. Right, wrong, that these are the goods which we are sending through Mr. Bhumik to Calcutta for this purposes. Now, once having got that, what should have they done after that? Was it required for them to verify the authenticity of those documents? Because you were an institution.
Yes.
It's not that a private man is sending, you are an institution. So any document that you had sent it, that document should also be with you in your records. Have the custom officers come to your institution and ask for those documents? So that satisfaction was also not drawn.
No, Lordship. Till date, they have not received.
So the reason to believe is you may try to argue that the reason to believe in the impugned order is a presumption
The presumption.
without any basis.
No, and sometimes, Lordship, I'll tell the true reason, Lordship. Sometimes what happens when these inspectors, they are newly appointed, they are in a aggressive mode and they want to do something. Like they have this inspector who was there. He was very, very aggressive and he wanted that he has to prove something in this case. He was very newly appointed, Lordship. So he wanted to prove somehow or the other this is a smuggled goods. But later on, when this was dealt in by Assistant Commissioner and the Commissioner in Shillong, they were very much cooperative and they were very cool and they did not harass this petitioner or they did not ask them to come or they did not come to their office because the matter was sub judice also. They understood this also, the senior officers. Because the office of the customs and this petitioner's business house is just opposite, Lordship. Anytime they could have visited their office.
Now this page 33.
Yes.
Summoning of documents.
Yes, Your Lord.
Yes, Mr. Kyle.
Sit.
There is an issue here.
Possibly pleased to see my affidavit.
No, I'll come to just a new thing. Let me understand.
What's-
See, you have made a Panchanama on 26/8. Right? Right? 26/8. Page 30. Come to page 30.
The repetition.
Writ petition. Right? You have a copy?
So there were 3 repetitions.
This is WPC 6204. Don't have a copy, I can give you the B file to you. Just a clarification I'm seeking from you. Now you come to page 30. That is the detention receipt. We'll call it Panchanama or the detention of the materials. Neither here nor there. Even if I am traveling, my wife is carrying gold, you can have a suspicion.
Yes.
You can detain that goods. Now you come to page 31. On the next day, you have said that we have detained gold. We have reason to believe that you are in possession of facts and documents which are material to the above inquiry, right? 31, you have got it?
Yes. Someone.
So under section 108, you have
Yes.
asked an authority of the petitioner organization to come before you
What's-
with general documents. Documents in support of dated on along with documents pertaining to transport of gold, diamond ornaments since 1/1/2017.
What's-
Right?
Yes.
Now, this is on 27.
Yes.
Then the person comes there. So-and-so, you have summoned so-and-so to appear within so-and-so. One day, the summon given to so-and-so was delivered 27, I don't know, so-and-so out of station. Kindly extend the time for compliance by at least a week.
Yes.
So what do you do? On 31/8/2017,
Yes, sir.
huh?
Yes, sir.
You issue a further notice under 108 itself.
Okay.
Right?
Okay.
Now, come to the third paragraph. You are hereby summoned under section so-and-so to appear before me, so-and-so, to give evidence truthfully on such matters, produce documents, so-and-so. If you fail to comply, you will be liable to be punished, so-and-so. So these are the documents now you are specified.
Okay.
And you have asked them to come on 1/9,
Okay.
right?
Yes.
This is on 31/8. So without waiting for that 1/9, how could you make this seizure on 31/8? Because you have not formed your mind till now.
What's it?
The reason to believe is not fortified.
Yeah, correct.
Then on 31/8 itself, you do it. And on 1/9, you issue the reason to believe forcing. But that documents which you were called for on 1/9, to arrive at that conclusion, you have not even perused. Yes, madam.
And there are a lot.
Correct me if I am wrong.
absolutely correct. Lordship is absolutely correct. And Lordship, these are so much of documents. Within one night.
Forget it. Forget it. I'm not on that 1 night or 2 night. But they themselves took that on 1/9, they wanted to examine it on 31/8. Now, without examining that, how could they reach a conclusion for Caesar under 110? Now you will have to show me materials that between the night of between the issuance of this order and the Caesar any time.
Time of the
21 hours, Lordship.
21 hours.
Date and,
9
place and-
numbers. So between this issuance of this and the Caesar, what happened? Huh?
Page 34.
Huh. Is a Caesar?
No, this was for that airport, Lordship. That time is for airport C.
Oh, that is why. Forget it. But between these two documents, because you have asked for the documents, that is to arrive at a satisfaction that these are things which have been brought through a route, otherwise not permissible. Now, how could you on the same day issue this Caesar without arriving at a satisfaction in the matter? Now, in your records, this would be there. This.
Paragraph 8 of my affidavit.
Huh?
Reply to, because this is mentioned in paragraph 7 of the writ petition.
Okay, what is the stand there in paragraph 7?
Paragraph, their contention is that the petitioner most respectfully beg to state that even after integrating the said document, the said custom officials most satisfactorily issued summons.
No. I'm not on that. I am on the question.
My reply.
I don't think so that they have dealt with that
My
point
reply
here.
is page 12, paragraph 8.
Paragraph 8. Para 8, page 12.
Page 12. That with regard to the amendments made in paragraph 7 of the writ petition, it is to be noted that the circumstances substantiating the verification of the is already discussed in foregoing paragraph, that is in paragraph 15. As the summons was issued to Sri K.K. Soni, who in the instant case delivered the gold articles to carrier for transportation to appear before the office with relevant record dated 2017. However, it was informed by letter dated 28/8/2017 that Sri Krishna Kumar Soni is out of station and he shall be coming back after 3 or 4 days, and thereafter request to extend the date for compliance of.
No. This I got it.
Further,
I got it. But what about your letter of 31, wherein you yourself said that bring it on first? Then what made you to make this Caesar on the same day itself?
proceed paragraph 9.
Paragraph 9.
With regard to the amendments made in paragraph 8, 9. 10,
No, this is wrong. This is wrong because you had given them time till 1/9. And on 31/8 itself, how could you have made this Caesar?
Some explanation are there. Petitioner stated CUR after giving considerable time and opportunity to produce the records with respect to the seized articles. Accordingly, the goods were seized under section 110 of Custom Act on reasonable belief that the goods are based on
Smuggled in nature.
etc. The reason to believe was also made known to the petitioner by letter dated 2017 in accordance with instruction 1 of 2017.
That again you have violated because that requires something else, the instruction.
The seizure was done following the principle of natural justice under the let down procedure. So that the seized goods were then provisionally released to the petitioner on 9/10/2017 on the Honorable Court's order dated 22/9/2017 after furnishing security and execution of deed to bond. The bond specified that the obligator said.
Okay, got it. But now, Mr. Cal,
Proceed.
what I may be wrong, just correct me, both of you.
Proceed.
Now that first notice is of 27/8, you are examining the matter to arrive at a conclusion that these are smuggled goods you wanted documents.
Yes.
Then page 33, because that person whom you addressed was not there.
Okay.
33, you again give a notice.
Okay.
Saying that appear before me on 1/9 with these documents. Why did you not wait? Or are they not required to wait? What is the purport of this notice? This is to arrive at a conclusion
They
that
wanted,
these materials of reason to believe that these are smuggled goods
because they wanted to see from where the goods was brought in.
brought in. That's what.
How-
Now, without waiting for their own 1/9, how could have they made this searcher on 31/8? As an officer I'm asking you, not as a petitioner counsel. What is the purport behind this? Because they themselves said, at least till 31/8, when they issued this letter, they were not having materials to come to a conclusion that these are smuggled goods. So they gave you time till 1/9.
So that they could find out the origin of the.
Origin of things and then come to a reasonably believe, no, we are going to seize it. Now, before arriving at that, how could this 31/8 on the same day be issued? Or is it permissible? The smile of Madam says that it's permissible.
It is not permissible. That's what Lordship, actually, section 120.
Where is your statement then to that effect? That they should not have done it in this manner. On 31/8, the seizure could not have been made
This
because
is of-
at least till 1/9 we were given time.
I will accept that Lordship, what Lordship has observed, we have not taken in our petition. We have only said that 31st, since the seizure was done, and on first, the reasons to be believed that reasons for belief that letter also we got it on 4th, Lordship. 1/9 what they have issued, that we received only on 4th, Lordship. It was given to us on 4th.
It's page 35 of the repetition.
Hmm.
He reads Lordship, we'll get something else.
No, once you have committed yourself, you have asked for the documents. How could you, now from the records you see, once this notice would be there, note sheets would be there leading to this 31/8, page 33.
No.
Just check up. And what is the reason given for the seizure?
Page 35.
Hmm.
The repetition.
Hmm.
Page 35,
Hmm.
lecture 6.
Hmm.
Is addressed to Sonam Jewelers. Subject reasonable belief for seizure case number so and so, value rupees so and so. In the aforementioned case, the person Sri Sunanda Phyllis 337 grams of gold kada bangle in his left arms and also found carrying gold and diamond jewelry in his handbag.
Hmm.
Purchaser produced delivery channel number so and so in support of gold and diamond jewelry, but would neither produce any document in support of gold bangle kada, which was concealed in his arm, nor could provide any satisfactory answer in this regard. And observe that even after passing of 4 days, no one, including any authorized person representative of money and the jewelry, produce any record document in support of purchase, possession, sale, transportation, or job work, etc. of the detailed goods, thereby pointing out towards the smuggling nature of the in tactics to tamper with that and hamper delay in verification process. Moreover, delivery number so and so, dated 26/2017, submitted by Sri Sunandar Bhamik, 28/2017, appears to be manufactured. After thought, they are pointing out towards nullified intention of the possessor owner of the goods, thus necessitating a detailed investigation. Further, the non-declaration of the exact destination, address and other as per Rule 10 of invoice to GST 2017 hints toward the smuggling nature of the detained goods. The number of seizure goods in or around Guwahati.
Now we have read it, Mr. You need not take the trouble. We have read it. Now you come here, the most relevant thing here is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line of that paragraph. Further. 10th line of the paragraph. In the above mentioned that paragraph 10th line, further. Consigner is adopting delay tactics to tamper with the evidences and hamper and delay the verification. How did you come to this conclusion when you had already granted him time till 1/9/2017 to produce and see the documents that are being produced? Page 33. Delivery challan book,
Yes.
33.
It was the repetition.
Writ petition. 33 of the writ petition, that is the summon under 108.
Delivery challan.
Challan book used for transportation of gold and diamond for financial year 2016, 17, 18 till date. Now, have you perused this before issuing this, page 35? There was no occasion. Then, now you check your records. See what transpired after this letter dated 31/8/2017, number 6273 was issued and the seizure made. So you never had arrived at a conclusion with regard to the material detained, because the documents you were seeking for arriving at that conclusion, you had never perused that. Anything more?
That's it.
No, no, only one judgment of this honorable judge. Which
It's in the
lodged-
compilation.
Yes, it's in the. it's
Page?
Page 63.
Mr. Cal,
Lots of-
please look into that in your records. Page?
Page 63, Lord. The relevant portion of page 66, Lord. Paragraph 15, Lord. In this case, the seizure order merely reproduces the language of subsection 3 of section 44 of the AGST Act, but does not record any objective reason for ordering the seizure. The necessity of recording reason is important, as in that event another authority can scrutinize as to whether the reasons are based on objective consideration. But in the present case, reasons are conspicuous by their absence, and supplementary reasons sought to be projected by the learned counsel for the revenue cannot satisfy the legal requirement of recording reasons prior to making of the seizure.
Because you did not have that material which you wanted. And you had called for that material only on 31/8. And on the same day, you are making this seizure. You show me that seizure was not made on, if you can show that seizure was made either on the failure of the part of the authority, respondents or the petitioner to produce these documents in the schedule, or after perusing that on production.
Lordship may come to my. I want to show some annexures. Of the page 21. 21 and 22.
These are there in the writ petition also.
Yes, Lordship. Then Lordship, annexure 3. That is also in the writ petition. 24 is also writ petition. Then page 25. Then by Sunanda.
28.
Page 25. With respect to aforesaid, I am producing that in respect of detention of gold and ornaments on 26/8/2017, which are. Then on 27/8/2017, again and he produced these documents, same documents. This time one more document was produced. Then I'd like to inform you that above referred summons has been issued by your good office for reference of Sri Sunanda Bhaumik before you today. That is 38/2017 with due respect. I'd like to inform you that
Sunanda Bhaumik was admitted in hospital as he was suffering from severe chest pain. Copy issued by the concerned hospital is annexed here with for your perusal. Thus, it shall not be possible him to appear before you on 30/2017. And let's see, next page is the certificate.
Forget it. Come to 34.
Then page, let's see, another page 32 also is important.
Hmm.
This is about summon of 19/2019, 19/2017.
Hmm.
I would like to inform that Manikchand's son about with little mobility. Further, he is out of station for treatment and is expected to come after 15 days at least. So it shall not be possible for him to attend the.
So, Mr. We got it. They were trying to buy time.
Yes, sir.
We get it. We get it. We get it. They were trying to buy time, and in the meantime, a presumption can be drawn that they were trying to manufacture their documents.
Documents were already produced by them.
Now you come to the page 32, the date of that letter and your date of receipt. It's 19.
19/2017.
Okay. 19 is the date.
Yes, sir.
If you come to page 34,
34 is 31/8/2017.
when that gentleman was supposed to appear before you with the documents, with the records, right?
It was served on them on 38 itself.
30, fine, got it. But first he has to appear before you with the documents.
Yes.
Now, what have you done? If you come to page 35, you don't know on 31/8 whether Mr. Soni is appearing before you or not. You can't draw that presumption on 31/8 that they will not come. Because this letter came to you only on 1.
Not so.
Now, on 31/8 itself, why did you make this scissor? Without drawing a conclusion on 31/8 prior to this. And then you proceed to issue this reason to believe.
Yes, sir.
Not there.
On 19/2017.
17. So that you wanted the documents to draw that conclusion. Without drawing that conclusion, how could you go further on 31/8 itself? Because 31/8 is the date when you made the seizure. So before that, the reason to believe should be there. We condone. We will take this 19. Okay, we will say that this is equal to, it's done on the same day. Okay, fine. But from what materials? Because it's only on 19 that you required them to produce the documents. Until 19 you don't know. Because you set the ball rolling on 31/8 by making this seizure. So 110 is very clear. If the proper officer has reason to believe that any goods are liable to confiscation under the Act, he may seize such goods. Now, for that, arriving at that conclusion that these are not smuggled goods, giving them an opportunity, that letter was issued, asking them to produce those delivery challans and all. So before that challans could be placed, why did you do this?
Challans were already produced by them.
Then why are you asking here?
Lordship from other documents.
No, that is it, till date.
And Lordship has seen
Huh.
the letter dated.
You come here.
1917,
You come here.
page 32.
No, 34. Come to page 34. Delivery challan book used for transportation of gold, diamond for financial year till date. This is to just verify whether the document produced before you by Bhaumik matches with their official records. Records pertaining to purchase of the detained ornaments.
Yes, sir.
Then stock register, sale register, purchase register, payment register of purchase and sale of the detained goods. Mr. Kel, I'm stuck here, unfortunately.
Yes,
And when I'm stuck, I'm stuck. So take me out of this. You go through your records. We'll not rush in. Go through your records. You're just GST compliance and all that will not work because you have not examined the original records before Caesar.
That is correct.
Will not go into that.
That is correct.
Just show me why it was done. You may have a very valid reason. Go through it, give it to me. Your affidavits don't reveal.
Yes, it is because no amendments was made to that effect in the repetition, so reply has not come to that. effect.
Fine, but that is, you will have to explain your action because they have at least said that before making that Caesar, there was no reason to believe notice. Finished.
But that was there.
Unfortunately, this maybe rightly, wrongly, I don't know. It came to my notice.
Action circumstance of the case suggest to believe.
You have not reached that stage because on 31/8,
That I
when you issued that letter, you had not arrived that these are all smuggled goods.
pointed out. I have to.
Just go through that. When? When will you have it? Tuesday. Any problem on Tuesday? I've invested some time, I'll keep it parted.
Yes.
I don't know what judgment will come out.
Come out brightly, Lord.
No, madam, please.
Good or
I'm-
bad, whatever.
No, I'm not on that. Some issues that I raise, you know, I don't have much of experience in this line. If I'm going on a wrong track, please correct me. It's not as a advocate for the petitioner, as a counsel, officer of the court, kindly point that out to me.
Lordship, if we both were having that conversation, the point that Lordship has taken, we have missed it. It was one.
It's not a question of missing it. It's a question of fluke. Dekha, heard the parties at length. Hearing remains inconclusive. List the matter again on 11/6, 2024 for further hearing. Mr. I'll not mention it. You remind me. I forget. You remind me.
Much of.
So if that is there, if that's reason to believe Caesar goes, we need not go into anything else.
Yes, sir.
Small order will do. And if I'm wrong, correct me. And tomorrow I get to know I made a mistake, you will be in trouble.
Also consult with my officers also.
You do it.
What is the right thing you will place before?
Please do, sir.
Nothing is to
Please.
be hidden.
Nothing. You are for the government of India. They may have to have something to hide. You can't hide anything. Rosin.
Item 4.
Yes,
I
what
have
is?
taken instruction, my lord.
Hmm.
The petitioner needs to place a letter for revalidation, my lord,
You will pay him.
along with a pre-receipt bill, my lord.
You do one thing. Get this instruction in writing from your officer. Any officer who is competent, get it in writing. We'll have it on Thursday. We'll dispose it of.
Yes.
Right, ma'am?
Yes.
Tell your senior that they are agreed. So they'll bring it on writing and then we will give it. Right?
In their official pad, my lord.
Yes.
Diploma.
And also get an instruction with regard to that 250 that he is claiming. That you say because you are not paid him because he is part. But he says that I was there only for 22 days and you have already deducted the charge for 1 month. Right?
Tell him, my lord, for their reply, my lord, they have given me some instruction, my lord.
Get me both together on Thursday. By slip Thursday. Thursday.